lot of DJ and KJ.
Well, I'm very glad to come in and find it's quite cool in here, Mr. Charland.
Yes, my lord, I share your views on that.
My immediate thought is it's very cool. So if it gets too cool, I think I've got a switch. Let me know if you're in any discomfort one way or the other.
Well, thank you. I'm very grateful. Good morning, my lord.
Oh, I've got a. Let's see, I've got this. Yes. So yes, Mr. Charland.
Thank you very much, my lord. Good morning, my lords and my lady. I appear on behalf of the appellant in this matter, Suffolk County Council, leading Mr. Lee Parkhill, instructed by
Who appeared below.
He did, yes, I did not. Instructed by Suffolk Legal Services. My learned friends, Mr. David Wolfe, QC, who didn't appear below, and Ms. Catherine Rowland, who did, appear in behalf of the respondents in this matter, who I shall refer to as BG and KG.
Yeah, B and K would be all right.
B and K, okay. Instructed by Feynman's solicitors. Before I commence my submissions, 3 brief housekeeping matters, my lords and my lady. First, anonymity. An anonymity order was made below, but it hasn't found its way into the bundles. I've got copies if you would like to see them, see the order. But if it's not, neither party is suggesting that the anonymity order shouldn't continue.
No,
so
well, I must continue, mustn't it? It must continue, yes, of course.
Grateful.
That extends just to the claimants. It doesn't extend to the local authority, does it?
It doesn't, no, my lord.
Okay, right.
Oh, yeah, sorry, the claimants and the mother, who's the litigation friend.
Of course, yes.
Who perhaps we
As
refer
well
to
as standing up, Mr. Wolfe, your junior is tugging your...
Concerned that the live stream hasn't started as yet because the litigation friend is watching from home and is very concerned.
Well, the light is on, so I hope the light...
It's saying on.
It is on.
I think there's a delay on it.
It's a very short delay, if there's any delay at all.
Are you in? Is Miss Rowland in text communication with her
I am,
client?
Lord, yes.
All right. Well, would you let Mr. Wolfe know, or let us know in a couple of minutes if there is a delay on it?
Yeah, it should be okay now though.
It is starting now.
Yes, exactly. For obvious reasons, I say for obvious reasons. For reasons, there is a delay. Okay, so what were you saying? Housekeeping.
Yes. Anonymity order applies to the 2 claimants and the claimant's mother,
but not to the local authority. Yes?
Yes, my lord. That's the first piece of housekeeping. Second piece relates to a couple of pages omitted by accident from the core bundle. I've got copies. They're part of the claim below.
I think we had them yesterday, but we better just have them again in case.
You may well have, my lord. And if I also hand up, so there's 3 copies of.
Right. Yes, we had this Miss Rowland. This was Miss Rowland's the document signed by her. We had that.
Excellent. I think there was a degree of confusion on what's happening, but those are paginated, and if they haven't already been inserted, suggest that they are inserted in the core bundle.
Yeah, thank you.
Place. And then the third piece of housekeeping, I've also handed up Regulation 3 of the eligibility criteria regulations. That relates to carers, which we may touch on, and I suggest you insert that behind Reg 2 in tab 6 of the authorities bundle.
Thank you.
While you're dealing with the authorities bundle,
yes, my lady.
Mr. Charland, I did wonder why Section 1 of the 2014 Act wasn't in the bundle.
My lady, I think that is a fair point. It's not. I'm sure we can get copies over the short adjournment.
Thanks.
Okay. Yes. Thank you.
Thank you very much. This appeal, we say, raises 2 issues. Firstly, the extent to which the administrative court can, on an application for judicial review, grant relief in relation to decisions that are not challenged, and we say because of the passage of time are not challengeable. In the present case, the
Mr.
council made...
Charland, you're going to have to slow down.
Apologies, my
That's
lady.
right, we are trying to take notes.
So, first issue, say it again.
The extent to which the administrative court can, on an application for judicial review, grant relief in relation to decisions that are not challenged, and we say because of the passage of time are not challengeable. I'm taking this broadly from my skeleton argument,
you are.
which I'm developing, but that's paragraph 1. In the present case...
Is it still the first issue?
Yes. The council made a number of decisions that we say have never been challenged by the claimant in this judicial review or otherwise, including, firstly, the Care Act eligibility needs assessments completed in October 2019. That's the first decision not challenged. And I think it's fair to say it's common ground that that decision has never been challenged by the claimants in this judicial review.
Yeah.
The second decision we say that has not been challenged is the decision dated 3rd of March 2020 to no longer provide £3,000 per annum for both K and B, which was used to fund a family holiday in Florida.
And where is that decision set out?
That decision is in the supplementary...
In the letter?
That's the letter, yes, yes, which is in the supplementary bundle, my lord.
Yes. We'll come on to that.
Now, there is some confusion and dispute about whether this decision was challenged, which I'm going to come back to as I develop my submissions. At this stage, I would note it's not referred to in the N461 form in the section that says, what decisions are you challenging? And paragraph 1 of the respondent skeleton below refers to only challenging one decision, namely the decision set out in the 12th of November letter. So there's some dispute about whether that decision is challenged in these proceedings.
Well, the position is that when Mr. Justice Mostyn gave permission, he clearly referred to the earlier decision, the 3rd of March decision, didn't he? And try as I may, but you can tell me I'm wrong, I can't find in the judgment any part dealing with any application or challenge on behalf of the appellant that it wasn't open to the judge to examine the 3rd of March decision or indeed the 2019 assessments.
Well, the first point is Mr. Justice Mostyn, on any interpretation, did not give the claimants permission to challenge the October 2019 assessments.
We'll have to look at that, I think.
Of course.
Can't wait. Make your overall submissions, then we'll come back to
Great.
that. He didn't give permission to challenge anything other than the November decision. Is that what you're saying?
No.
Yeah, well, that is what we're saying. I think there's ambiguity about the 3rd of March decision.
That's
we say
what you're saying.
Yeah.
You're saying he didn't give permission
Yes.
to challenge anything
Yes.
other than the...
than the 12th of
Yeah.
November decision.
That's your... Right.
Yes.
Well, he said that if necessary, he would grant an extension of time, and an extension of time could only be necessary in relation to the 3rd of March decision.
Well, he made observations. There is no order granting an extension.
I think it would be better if we're going to look at this,
Yes.
as you can see, in quite a lot of detail. But in fairness to you, I think you should just outline your points on this, and then we'll come back. I think this is quite an important point of the case,
Yeah,
Mr.
well,
Charland, which is why we're focusing on it.
Completely agree, my lord. And I definitely will come back to it, and I will address the questions raised, and it's quite clear there's going to be a number of questions raised on this issue. So going back to my broad outline, the third decision that we say was not challenged is the November 2020 care plans.
So that's it. So number 1 was the October 19 assessments. Number 2 was the decision letter, and number 3 is the which kept the what date?
The November 2020 care plans.
Okay. Right.
And I would say it's common ground. This decision has never been challenged by the claimants in the judicial review. It's not articulated as being challenged in the N461 Mr. Justice Mostyn in granting permission doesn't refer to this decision or the eligibility assessment.
So those are the. Is there anything else you say that hasn't been challenged that could have been challenged of relevance?
No.
Those three.
Yes.
All right. Well, shall we start by looking at the application, the original application? How do you want to?
Well, my lord, I've got various introductory comments. I promise you I will go through chronologically. I'm going to take you to the factual background, which obviously includes the claim and Mr. Justice Mostyn's consideration of the matter and so forth. So I definitely am coming to this because I quite accept this is absolutely critical.
Thank you.
The appellant says that in the absence of a challenge to these decisions, it is trite law that such decisions must be treated as lawful. The Court of Appeal has repeatedly emphasised the importance of procedural rigour in judicial review claims, and that challenges should be limited to those set out in the claim form and the statement of facts and grounds. If the decisions referred to are treated as lawful, the claim fails, as these decisions, particularly the eligibility needs assessment, make clear that neither the respondents has a need for foreign holidays or payment for food and drink at cafes and so forth. If the court accepts the appellant's argument on this point, the appeal succeeds. There's no need to address the second issue. The second issue, my lords and my lady, is whether Suffolk County Council has the power or duty, pursuant to sections 18 or 19 of the Care Act 2004, to fund foreign holidays and recreational activities for B and K. The court is required to consider this matter on the basis of hypothetical facts, namely that the appellant has assessed, namely that the respondents have been assessed as having a need for foreign holidays and such recreational activities, when in fact the exact opposite has occurred. This issue turns on the meaning of the phrases need for care and support and the phrase eligible needs in the Care Act 2014. I'm not aware of any Court of Appeal authority on the meaning of those two phrases, although we say it's helpful first instance authority, particularly GS in Camden and the Aburas case. My lords and my lady, I was now going to turn to the factual background and go through it chronologically, and I'll take you to all the relevant documents, including Mr. Justice Mostyn's permission.
Well, you can take it that we've read, obviously, the judgment below very carefully.
Of course, my lord.
And as well as the preparatory documents you've prepared, and some of the original material. I don't think you need to go into the history in quite as much detail as the judge did.
I wasn't planning to, my lord.
Which isn't to say I'm criticising the judge for doing that.
Of course.
Because we've read it, I think you can assume we're broadly on top of it.
Yes, obviously the judge set it out in a lot of detail, and we say actually only a small part of that detail is relevant that the issues that this court has to determine. But I appreciate the court has read it carefully. So I'm planning to take the factual background briefly. I deal with this at paragraph 6 of my skeleton, which I'm just going to sort of speak to and develop. Respondents are brothers, aged 36 and 38 respectively. Both suffer from autism and a learning disability. Both have social care needs. They live together with their mother and stepfather. The respondent's mother, S, acts as their little litigation friend. She's also their main carer. As the court notes at paragraphs 6 and 7 of the judgment, both K and B receive employment and support allowance and personal independence payments. These are benefits which aren't the subject of the litigation but are relevant background. I understand B receives £280 per week, whilst K receives £191 per week.
Well, I see the summary of the events that you put in your skeleton, which is, as far as it goes, is, as far as I can see, accurate.
Yeah.
One thing from the background which struck me, purely for my part, Mr. Sharman being quite important, was that, and I don't want to spell out the details, but as a result of events that occurred involving the brothers at an institution some years ago,
Yes.
that has affected their, I can say capacity, maybe not the right word, their comfort, certainly, at least, in being out in the community in their locality.
Yes.
That's a fair point, isn't
It is.
We
It
need
is
to
a fair
develop it.
point.
But that's something that struck me, reading the history.
Yes, my lord. That's very much an accurate summary, and no dispute is taken.
We need to develop it, I think.
Yes, my lord. Just dealing with employment and support allowance, personal independence payments. That such payments are money to help with living costs if you're unable to work, such as universal costs, food, clothing. We say activities. Purpose of personal independence payment is to help with extra living costs if you have a long-term physical or mental health needs. So it's important to bear in mind the broader context when looking at how the Care Act is construed.
Well, this will take us to grounds 2 and 3.
Of course it will, my lord, yes.
I think, for my part, I'll resist asking you any questions about that. But putting down a marker, there are a number of questions that we're going to have about that if we get
Of course, my lord. Of course, my lord. Paragraph 7 of my skeleton argument, I set out that from 2011, appellant has met the respondent's care needs by making direct payments. Since 2014, that's included £3,000 towards the cost of
each.
Yes, my lord, each.
So your authority paid what for 4 years or 5 years? Direct payments for each of the respondents, totaling £6,000 per year.
I think it's 4 years. Yes.
For 4 years.
Yes.
For a holiday, you say in doing that, you say presumably you were exceeding your powers, do you?
Yes, my lord. Yes, and that wasn't the only payments we were making. That was the holiday payments.
Yeah.
We were also making other direct payments, which were used to fund trips and activities. Mrs. Justice Lang sets that out in detail in her judgment. It's our case that those payments were made in error.
When you say made in error, what was the error?
The error was that the need to attend trips and activities, holidays, were not care and support needs for the purposes of Section 9 of the Care Act or eligible needs, and therefore there's no power under Section 18, Section 19 to fund them. In October 2019,
just forgive me, my apologies. So for clarification, all those payments, because I think the last was in 2018, was it? The holiday payment.
I think the holiday payments 2018, the direct payments in relation to activities, I think ceased in November 2019. That's my understanding.
All right, let me just cut to it.
Yes.
All of those payments were made pursuant to the 2014 Act.
Yes, my lady.
Thank you. My apologies.
Of course, my lady. Paragraph 8 of my skeleton. In October 2019, the appellant reassessed the respondent's needs in the eligibility needs assessment. And I think it would be useful to turn to that document, which is in the supplementary bundle. Well, there's obviously 2 assessments, one for each individual. The first one is supplementary bundle beginning at A21.
So this is B.
Yes, this is B. The document that follows is K's assessment, but I don't think it's necessary to go to both unless the court wants to, because...
well, if there's any material difference, show us, but otherwise...
Of course, my lord. You'll see on page A21, this assessment was completed on the 18th of October 2019. And as I'm sure you're aware, this is a pro forma document, and it considers various areas of potential need, these are derived from the eligibility regulation. So on page A22, there is consideration of managing and maintaining nutrition. And it says B is unable to manage and maintain nutrition without assistance from a carer. And you can see a bit more detail what he can do. Can make a hot drink, but only under supervision. But needs support when eating to make sure he doesn't choke and remembers to chew.
These are all what called the outcomes under the regulations, aren't they? Isn't that right? These headings?
Yes, my lord.
Maintaining nutrition, etc.
Yes. Yes, as set out in Regulation 2.2 of the eligibility.
And B is unable to achieve these outcomes across the board.
Across the board, without support, yes. Yeah. And of course, the assessment of needs and eligible needs is both carer blind and resource blind. So the fact that B's needs are being met by his mother S doesn't prevent them from being needs. The fact that the carer is meeting those needs is relevant at subsequent stage in relation to section 18. So yes, in relation to all of these outcomes, there is need. At page A27, we have a summary, and on that page it notes that there's eligible needs in relation to each of the outcomes. And we'll look at the outcomes in more detail later.
So do I take it that at page A27,
yes,
and one looks at that table there, take the one fourth from the end, making use of necessary facilities or services in the local community, including public transport and recreational facilities or services. I suspect that is meant to replicate 221 of the 2015 regulations. Actually, the wording doesn't, does it?
No.
Because it suggests that it's confined to local community, whereas 221 does not confine it to the local community. Recreational facilities and services go beyond the local community.
Well, I'm going to make submissions on the correct interpretation of the regulation later.
I'm not even dealing with the interpretation, I'm actually just dealing with the wording.
Well, if we turn to the regulation in question, which is tab 6. So that's tab 6, first page. Specified outcomes are set out in subsection 2. And I says making use of necessary facilities or services in the local community.
Comma.
I don't think there is a. Is there a
There's
comma?
a comma in the regulation that's not in the form.
Right. Okay, I've scribbled on mine. I can't actually see the comma there.
There is a comma in the regulation.
Okay.
There's a comma in all the. This regulation has been copied in various documents. It's got the comma. But there isn't a comma on page A27. 27. Thank you.
I have a comma after the word transport. You have a comma earlier.
After transport.
Yes.
In the regulation.
Oh, right. Yes.
After. Well, let's have a look.
Sorry, I misunderstood. Yeah,
I'm looking. What page are you on in the regulations?
It's the first page of tab 6.
Regulation 2 or 3?
2. 2.
Okay. 2. There is a comma after transport.
Of course, yes, my lord.
There isn't in the. If we look on the form.
Yep.
I.e. the assessment. There isn't a comma after transport.
My lord, I quite accept that the comma is omitted, but we say that regulation 22I, the local community refers both to the transport and recreational facilities or services.
Well, I suppose the question is the phrase recreational facilities or services in I a subset of facilities or services, necessary facilities or services in the local community? Or is it a separate?
Yes, and we say it's a subset.
Well, why do you say that?
Because we say that that is the natural reading of it. Making use of necessary facilities or services in the local community is the broad class, then sets out including public transport, and recreational facilities or services.
Well,
I don't think you'd have if that was right, you wouldn't have a comma after transport.
No, exactly.
you'd have it after community, wouldn't you?
The one place you wouldn't have it is before and.
If the overall category is local community services, the comma should come after community, because it's isn't that right? Whereas here, the comma is after transport, which, for my part, my immediate reaction is it's not a subset of facilities within or services in the local community. It's a separate category.
Well, I would say including public transport, and recreational facilities is indicating that public transport and recreational facilities are distinct. They're obviously not the same thing, but they're both within the broad subset of the first part of regulation 22I, the necessary facilities or services in the local community. Otherwise, you would have had I and J. You would have had making use of necessary facilities or services in the local community, including public transport, J, making use of recreational facilities or services elsewhere.
Facilities or services in the local community, I'd have thought quite obviously includes recreational facilities or services. So it wouldn't really be adding anything.
Well, I think it quite obviously would include public transport, but for the avoidance of doubt, the drafters of the regulation have set out, and it's not an exhaustive list, what necessary facilities or services in the local community are being talked about. It includes public transport and recreational services, facilities or services. Well,
I mean, if we look at regulation 3,
yes,
which is the needs which the carer's criteria, it's phrased rather differently, isn't it?
it is, yes.
A, because there's a 7. The 7 does not include transport.
No.
But it also includes an 8.
Yes. Yes, it is drafted differently, and we say that is done because that makes clear that the recreational activities are not limited to the local community. It's split off, and that's what I say that supports our interpretation, because it is quite clear from Regulation 3 that 7 refers to local facilities or services, in the local community, whilst 8 is not so limited. So if in Reg 2 the draftsman wished to achieve the same result, you would have had that split. But we don't have that split.
So what's the thinking behind expressing it differently for carers than for the adults needing care support?
Well, I believe the thinking is carers. Carers may require respite care, That is a relatively common provision to carers. If carers are spending most of their time looking after individuals in need, there may be provision where the individuals in question are going to respite care and the carers have a break elsewhere. Not necessarily in the local
so the powers of the local authority to pay for is this what you're saying? Would be to includes the power to pay for carers to have recreational activity, to engage in recreational activities outside the local community, but not the adults needing support. Is that what you're saying?
Well, yeah,
Is that what you say the thinking is behind the way these regulations are drafted?
Well, my lord, I think that must be because we say Regulation 2 is limited to local community, but Regulation 3 has been drafted differently, so engagement in recreational activities is not so limited.
If a family have in the circumstances of this family are unable to go out much in their local community, one would have thought that going on an annual holiday would be an outcome from an eligible need necessary for developing and maintaining family relationships.
Well, I'm not sure we would accept that. Whilst respite care...
You can easily form the view that unless this family gets the chance to once a year to leave their home and go somewhere else, they would suffer from stress, anxiety, being cooped up in the home permanently. Certainly, it's that view could be taken, couldn't it? Developing and maintaining a family relationship. They go on holiday together. Doesn't that develop and maintain a family relationship? Certainly.
We mustn't give evidence.
Mustn't give evidence.
Yes, but my experience is perhaps to the contrary.
Yes, well.
But to be fair, you're probably not in these circumstances.
No, my lord, I completely accept that. Obviously, the first point is that is not what the council concluded in the eligibility needs assessment, which hasn't been challenged.
Well, you're going to take us to that.
Yes.
but we seem to have been drawn into this discussion, which is perhaps relevant to the data grounds.
Yeah.
At this point. What else do you want to say about given that you've taken us here, about the lady's point about the drafting of the regulation? Well, principally the lady's point.
Well, I'm not sure that there's much more I can add on the drafting. We say on interpretation of we say it doesn't arise because of the eligibility assessment conclusions, but leaving aside that, we say the correct interpretation of 2.2i is that recreational facilities or services is limited to the local community. And
for the adult, but not, it would seem, for the carers.
Yes, my lord, because the regulations have been drafted differently.
So if one of the things that the person being assessed enjoyed and or needed as part of their general care was, for instance, some sort of swimming, and there was no swimming pool in the local community, you couldn't assess them to travel to a nearby town to swim.
Well, my lord, the distinction drawn by the council in this case is between the provision of paying for the admission to the swimming bars and paying for a carer to assist the individual getting to the swimming baths and utilising the swimming baths. I don't think that any particular issue has been considered by the council in relation to geographical scope.
Well, take bird watching, which I think I've read is an interest of at least one of these young men.
Yes, my lord.
And is it both of them? Both of them.
Yeah.
So they go to Minsmere, which is not too far from where they live. But suppose they wanted to go to North Norfolk, or
Titchwell.
exactly. Supposing they wanted to go, could the local authority is it not empowered to pay for that?
Well, it's not empowered to pay for the admission, because if you look at the specific outcomes, it's making use of facilities. It's not paying for facilities.
Right, I think that's splitting hairs.
Well, no, my lord, it's not. If we look at the specific outcomes, first one, managing and maintaining nutrition. That doesn't say the provision of food, and that's an important distinction.
Okay. Well, that all goes to the quantum, doesn't it, rather than the principle?
No, my lord. The principle is universal needs such as food, clothing, activities are funded out of the benefit scheme. What is funded under the Care Act is looked after needs, assisting the individual in question, maintaining nutrition. So someone to perhaps feed the individual or make sure they don't choke, but it doesn't include buying the food. Now, obviously, the individuals in question may have a like of gourmet dining, but there's no basis for saying that what was going to a 3-star Michelin restaurant would improve their well-being. There is a obligation, and that's an important distinction.
Okay, maybe, but if you accept that it's within the powers of the local authority to support them to make use of recreational facilities in Suffolk, such as Minsmere, on what basis do you say it doesn't extend to, however you fund it, making use of facilities by taking them up to North Norfolk?
Well, our case is the powers, if they were going to North Norfolk, and the question is whether that is within the local community, and that is a phrase that may be subject to dispute. But we say, if you look at the limitation placed in relation to the outcomes, it's different for carers. And there must have been a reason why the regulations were phrased differently.
Well, that's what we're trying to understand.
Well, I assume that
Would you like to shed light on it?
I will try, my lady. I'm clearly not doing a very good job so far. I assume that the drafters of the regulations envisaged that specified outcomes include making use of local community facilities, but they didn't envisage, for whatever reason, going to Scotland to go bird watching.
But isn't that illogical?
Well, I don't accept it is illogical, but that's, we say, a decision for Parliament. Parliament may do things that judges think are illogical, immoral, illegal. But I think if one looks at the language of the two regulations, contrast the two, that is the natural meaning of the wording.
Of course, your authority for 4 years took a different view.
Yeah, my lord, I quite accept that. We're not suggesting otherwise. Local authorities, like lots of public authorities, sometimes get things wrong.
Do you also accept that nothing had changed insofar as B&K are concerned as to their physical and other needs as between the last holiday and then when they were subsequently assessed?
Yes, that? My lady, that is accepted. And I refer to, I think, one of the footnotes, cases where individuals have been reassessed, the MacDonald case, the Davies case, where there's been no improvement of their condition, but the local authority has lawfully reduced the package, to put it in sort of somewhat colloquial terms. MacDonald was a Supreme Court decision under the old statutory regime. Davies was under the new statutory regime.
Right.
But my lord, the critical point here, even if I'm wrong on this local communities point, which reading the court perhaps you may think I am wrong, the distinction that the council is drawing is between assisting the individual making use of these recreational activities, whether they're in the local area or potentially otherwise, by providing support to enable them to access it and actually paying for it. So the thing is, we don't pay for food, but we do pay for support to enable someone to eat. We don't pay for clothing, but we would pay for support to ensure that someone is appropriately clothed.
That distinction, it involves a second re-evaluation from what was decided for the previous 4 years, doesn't it? On the one hand, in 2019, so there's a second. First of all, you decided, contrary to your previous view, the holidays outside the local community didn't count as recreational facilities or services within I. But also you decided that paying for them would not count as making use. Or rather, paying for them was going further than simply paying to enable them to make use of any facilities and services.
Yes, and I think, in fairness, if you look at the 3rd of March decision, the focus is very much on the latter, not the local community point.
Yeah.
So I think the local community point is something that's arisen today. I've tried to deal with it as best as I can, but I don't think the council were relying on this particular point, or at least expressly. But yes, we say you have all these list of outcomes. Obviously, you can't maintain nutrition if you don't have any food. But the purpose of the Care Act is not to provide food, drink, clothing.
No.
And that's an absolutely critical point.
But again, I'm being simplistic here, but I apprehend that the cost of taking to men with the difficulties that B and K have on holiday, there are different costs, greater costs and greater, it's more complicated and greater. So would even on your interpretation, narrow your re-evaluation, wouldn't some outcomes be covered under I, even if it wasn't the whole cost?
Well, if there was a carer attending with them, the cost of the carer, yes. But B and K, because of their past experience, will not work with any other carer.
So because their mother and stepfather are providing the services which could have been provided by an independent carer, they cannot have the money.
They can't have the money in relation to this, my lady. Yeah, that is correct. But can I make a couple of further points? They are receiving money, which we say covers food, clothing, activities, from the benefits. That's the first point. Perhaps the point, given my lady's look at me, is perhaps not wholly convinced her yet.
I have been told about my looks.
Yes.
And the second point, my lady, I quite understand looking at the impact on this family and the funding. But I don't think it's irrelevant that they are receiving just under £500 per week in sort of employment support allowance and personal independence payment. But the second point, my lady, is the council have offered. Let me. Could I ask you to turn to the core bundle A147? So what we are looking at here is the council skeleton below. So these were the submissions made to Mrs. Justice Lang. And could I ask the court to read paragraphs 33 and 34 to themselves?
Thank you.
So the court is rightly concerned about the impact on the family's finances and the impact that will have on the various individuals. And what you have at paragraph 33 to 34 is the council's essential solution to this issue. The indication that whilst you can't generally pay family members, because the direct payment regulations say so, there's an exception where it's necessary to pay the relative. And you'll see there, defendants expressed a willingness to apply that exception and therefore to pay S for the care of K and B.
Right.
So that's not relevant to the precise meaning of the particular phrases in the Care Act, but I think it's relevant to the broader concern that the court legitimately has about the resources this family are receiving.
Okay. Now you were going through the assessment.
Yes,
the October assessment.
Yes.
And we alighted on the punctuation in the heading, making use of necessary facilities or services in the local community, including public transport, comma omitted, and recreational services or physical services. What else, if anything, do you want to say about this assessment?
Well, I just wanted to, A35, under the heading, what are your worries and concerns, the various needs are set out. So K needs prompting to take a shower, to wash himself, and all those needs you'll see in the next column are assessed as eligible needs. I think that's really all I need to take from that. If I return to paragraph 8 of my skeleton argument, and say, in respect to recreational activities, the assessment concludes that respondents need someone with them when doing so. The assessments did not identify that respondents needed to take a holiday or needed to be provided with particular recreational activity.
And just so I'm clear. We're going to come back to ground one, but one of your points is this assessment was never challenged.
Yes.
And is it your intention that if there was going to be a challenge along the lines we've been debating with you this morning, that was where that was the decision which should have been challenged?
Yes. Well, if the claimant says that assessment doesn't accurately assess my needs or eligible needs, that's the decision that should have been challenged, yes.
Can I get this absolutely right?
Of course, my lady.
Are you saying the assessment of itself represents a decision?
Yes, my lady. And they are regularly challenged by claimants, and the court considers judicial review of assessments, care plans on a regular basis. There's case law, a case called Irena's Child, that a court of appeal authority that says that the courts must treat assessments as a document produced by a busy social worker and shouldn't be scrutinised in the way that a QC would scrutinise legislation. But yes, that is precisely my point, my lady.
But if it's subsequently transpired that whether in this case or some other case, it was determined that that assessment had been conducted on a legally flawed basis, you'd be obliged to reassess.
If it was challenged in judicial review in time or an extension of time was granted and the court quashed it, yes, we would.
Well, more
But that didn't happen in this case. It wasn't
more
challenged, it wasn't
more
quashed.
generally, though, if the council knows that the assessment it had carried out proceeded on a basis which the courts have now determined authoritatively, albeit in a different case, was legally flawed, then you couldn't rely on that assessment, could you? Because you'd know it was legally flawed.
But my lord, that raises a hugely difficult legal issue. If you say have two decisions made on the same day, but only one is challenged, two identical decisions made on the same day, only one is challenged, does the person who didn't challenge benefit from the challenge? The answer is generally not. But that's quite a complicated issue.
You're a public body, and if you know that the decision you made made assumptions about the law which it now knows are wrong, then you'd have to reassess, wouldn't you? I don't see how you could proceed knowing that using an assessment you knew was wrong as a matter of law. That's not a question of the whether or not that party had challenged it or not. It's just that the authority would know it was wrong.
Well, my lord, I don't think it follows.
Well, what happens with your second and third grounds then? If you're inviting us to rule on your second and third grounds.
Well, I'm not inviting you. I'm inviting you to dismiss the case on ground one.
Yeah.
But if you're against me on that, we have an alternative argument. We say this case should end at the end of ground one.
I see.
But I have to recognise, I think rightly so, given the questioning, that the court will not inevitably accept the correctness of ground one.
And if we didn't,
yes,
and if we proceeded, if we proceeded to rule on grounds 2 and 3,
yeah,
what do you say to my lord's point then?
Well, if the court essentially disregards what I say is, well, if the court somehow concludes that the eligibility assessments were actually challenged, and I can't see how they can because it's never been suggested that they were, and therefore they are subject to challenge in this litigation, the court is able to make some rulings in relation to them, but that turns on the factual prerequisite of whether they are or are not challenged. This court jurisdiction draws.
What you seem to be saying is that public bodies can go on happily dealing with things on a flawed legal basis unless that specific decision is challenged. And it seems to me that can't be right. All the time, public authorities have to reflect on what the law is, and the law, of course, is changing all the time. And I mean, if there's a new statute or a new decision of the court, it might mean that the authority has to reassess positions in many cases. The law's changed or the law's been clarified. And I don't think it can be right that you can say, well, every assessment we've made, because it hasn't been challenged within time, is inviolable if you know that they were on an incorrect legal basis. I just find that an astonishing proposition.
Well, I'm going to take you to the relevant authorities in this area shortly, but unless and until a decision is challenged, we say it is lawful.
Yes, but it may well be the decision was lawful, but subsequently relying upon or implementing that decision in the knowledge it was based upon an incorrect analysis of the law, that would be unlawful. So you have an assessment, that was lawful,
yeah.
But then when you then make a decision as to what to pay based on that assessment, if in fact you by that stage know that the assessment was based upon an incorrect legal analysis, it seems to me it would be unlawful to implement.
Well, we have made a decision, that's the care plan,
yeah,
and that's not challenged either. Now, maybe it should have been.
But now you've got Mr. Justice Lang's decision as to what the relevant applicable law is. Surely going forward now, you've subject to, unless it's overturned in this court, going forward you'd have to take that into account, wouldn't you?
Well, unless it's overturned in this court, we are obviously bound by Mrs. Justice Lang's decision. Yes.
Well, it goes further than that, because in your skeleton argument, although you said at paragraph 41 that if you're right on ground 1, ground 2 doesn't arise.
No, because
What you said in 59 was, further, both issues raised, the correct approach to JR claims and whether the court is entitled to grant relief and the proper scope of the duties under the Care Act are matters of considerable importance upon which the Court of Appeal's guidance will be beneficial. So we've been scratching our heads about that.
Well, my lord,
because we thought we'd like to help you, Mr. Charlotte.
And I'm very grateful for that.
Forgive me for teasing. But I mean, surely it would be. Are you saying we should be completely silent about this if we're and then it goes back and there's another challenge? I mean, would it help local authorities to know what this court thinks about this?
Well, my lord,
and particularly, if I may say so, as your local authority for 4 years was, on your case, labouring under an serious and expensive misapprehension as to what your powers extended to.
Well, I think this goes to the point whether courts should consider cases on the basis of hypothetical facts. The facts in this case are we determined there was no need for holiday or recreational activities. Essentially, you're being asked to determine the issue on the basis we assessed that there were needs and whether, if that was the assessment, whether there's a power under Section 18, Section 19. And the House of Lords in the Wynne case has said it's not the role of courts to opine on hypothetical.
When you asked us in paragraph 59 of your document, you said to us guidance would be beneficial. What were you thinking of?
Well, I was thinking on, can we get permission to get to the Court of Appeal for a substantive hearing? That's what I was thinking of, my lord.
Yeah, good answer. But then seriously, obviously any guidance we give would be subject to the facts of the case.
Yes.
Okay. Right.
But the trouble is, on the facts of the case, they don't arise because we have not assessed them as having a need for holidays. That's the problem.
Yes, but that assessment is based on your interpretation of the Care Act.
Absolutely, and
Yes.
that assessment is not challenged, and therefore the court must treat it as lawful. And it follows, if it has to treat it as lawful, that the individuals in question don't have a need for holiday.
So you're really withdrawing your request for guidance on the
Well, I'm saying it would essentially be obiter on the basis of hypothetical facts, and the House of Lords has indicated that that is not an appropriate use of judicial resources generally. The court may want. Yeah,
we've got Mrs. Justice Beverley Lang's judgment, which you accept is binding as a first instance judgment.
Yeah.
It may be, I don't know, that when we consider it, we may agree it completely with it or disagree with it, if we considered it, or we may think that she was right in some respects and not others. Wouldn't it be helpful to local authorities across the country to know what this court thinks about that? That's what you thought when you asked for permission. And that's what Justice Similar no doubt had in mind when she granted it, amongst other things.
Well, if you're with me on ground one, any comments would be on hypothetical facts and would be obiter, and therefore they would be of limited assistance.
Okay.
I don't think I can take the point any further.
I think that's been very helpful, and we'll come back to that in due course. But we all think we should get to ground one because that clearly is central to your appeal.
Yes, my lord. I was taking you through the facts.
were,
I was
of
going
course
to
you were.
go to the particular documents,
well,
including Mr. Justice Justin's.
Carry on doing that.
Yeah.
And I'll try not to interrupt.
It's not just you, my lord. Paragraph 9.
It has been, for the record, it's been mainly. Apart from the lady's looking at you. Yes. Okay, so where we go from? That's what you want to say about those.
Yes, and then chronologically, the next important decision is the 3rd of March letter,
which is in the supplementary.
Supplementary bundle at A37. This is set out in full in the court judgment. Yeah. Even if one hasn't turned to it, if the court hasn't turned to it, the court will have read it. And you'll see at the beginning that there's reference, obviously quite a lot of ongoing correspondence. And in this document, the council sets out its understanding of the Care Act provisions and what amounts to a need for care and support and an eligible need. And you'll see over the page at A38, it draws the distinction between support costs, which the council is responsible. This is the table. Support costs, which the council is responsible for, and universal costs, which the council says it's not responsible for. So the cost of food, accessing an activity, participating in a hobby, clothing, housing, etc., etc. So, and you'll see on page A37, there's reference to historic one-off payments for holidays. Explains that the council is no longer including payment for such holidays in personal budgets. And the reason for that is explained that it's not a Care Act eligible need. Council can only use this particular budget to meet the council's statutory function.
The distinction drawn there is between paying customers holiday costs and meeting the cost of support that they need to achieve a holiday.
Yes. So for example, if they went somewhere hot, a carer would need to ensure that they're appropriately dressed, have suntan lotion, etc., etc. And of course, in this case, S was doing that. And you'll see from our skeleton argument, we've offered to pay S for that care, but that hasn't been taken up.
Do you say this is a decision?
Yes, my lord.
And what is the decision?
Well, the decision here is that we are not going to continue to pay the £3,000 one-off holiday cost, and there is an explanation of why we're not going to pay that going forward.
And that represents the totality of the decision.
Well, essentially, there's an explanation of the decision, and then there's sort of discussion about support and universal costs. But Mrs. Justice Lang characterised the decision on the 3rd of March as withdrawing funding for holidays, and we suggest that that's an accurate characterisation, and that the 12th of November was ceasing to make direct payments. Claim been using for recreational activities. So that's how the court below analysed it, and we think that's a fair analysis.
Well, what it says is, it is my view that they may have eligible support needs when on holiday. It would appear that you are meeting these needs. Therefore, there are no unmet needs.
Yes.
If that is not the case, please do let me know.
Yes. So
I'm not really sure where the decision is here.
What is being said there is we're not going to be paying for holidays. It's our understanding that in relation to support on holiday, you, S, are meeting those needs. So ensuring they're maintaining nutrition, ensuring they're appropriately addressed for the weather. But if we have misunderstood that, let us know.
This looks like this looks to me as though it's initiating a discussion about it. And it's not addressed to either of the claimants, but to their mother. So for my part, I would some doubt as to whether it is a definitive decision, but rather when the decision is made on the 12th of November, it is notified formally to the claimants in letters to them. This looks to me like it's forming part of an ongoing correspondence. And the one possible decision it does refer to is that Suffolk County Council is no longer including holiday and travel accommodation costs in personal budgets because it has been identified. Now that seems there was a decision of the council at some point. I don't think we've seen that. We don't know when it was made or what consideration was given to it.
Well, the court characterised this. Sorry.
Well, do you say this was a decision? I'm sorry. On the March list. The March.
Yes, I do say it's a decision. It's a decision that they're not going to continue to fund the cost of holiday.
Okay, all right. But
in relation to support on holidays, the council is saying, well, it's our understanding that you are providing support and therefore you don't need anything from us. But if we're wrong on that, let us know. So there's ongoing debate in relation to that. But the consistent approach from S is no one else can provide care, so she is providing care.
So so if it's a decision, why wasn't it notified to the claimants? And how could they be out of time challenging it?
Well, time to challenge decision arises from date of section 54, CPR 54.5. Time begins not date of knowledge, but date of decision being made. That's the Press Act case. And
it's put in a drawer.
Well, the thing is, there's no evidence that they weren't aware of this at the time, and that they sought an extent.
No evidence that they were. And we know that when you want to notify these claimants of a decision, you write to them. You didn't write to them about this. You sent it to somebody who I don't know whether she has a power of attorney to act on their behalf or has some other authority to receive communications from them. But there's no evidence before this court that this decision was ever communicated to the claimants.
Well, the claimants sent a letter before action in response to it, so that would perhaps suggest they were aware of it.
Let's just look at what happens at the end of the letter.
Yes.
What needs to happen? And it was first bullet. Think about the short break. Second bullet, the direct payments team will complete the financial review. Yeah.
Yep.
And then there's a reference to mental capacity assessments and best interest decision regarding. So that's language I recognise from the Mental Capacity Act.
Yes, my lord.
But this is still talking about B and K in the third person. It's not a decision addressed to. There isn't a decision addressed to them. It looks as though there are various things that need to happen before the decision is addressed to them.
Well, my lord, in relation to the decision that the council will no longer be funding holidays, there is.
Yeah, hang on. I'm just. Sorry, I'm so sorry. No, I shouldn't turn off anyway. So sorry. Lord Justice Phillips didn't have a clear line of sight.
Some may say that's a benefit, my lord.
Sorry.
None of this suggests that the decision that they weren't going to fund holidays was contingent on anything.
Isn't it?
No.
I will contact you again to discuss the next steps.
Yes, and that relates to the short break services that are being offered. and so forth.
I don't read this as ruling out the mother's right to come back and make representations as to the position. So
I mean, yes, exactly. I mean, if you look at, we've all looked now at this penultimate paragraph on 37. If that is not the case, do please let me know, and I'll arrange an assessment conversation with you, that's the mother, to look into this further. As my Lord Justice Phillips has pointed out, all of this is directed to the mother.
Well, yes, but that particular comment relates to support on holiday.
Yeah.
Yes, not the payment of holiday. So there was no suggestion that there was contingent. I quite accept this letter was written to K and B's mother. K and B instructed solicitors acting with their litigation friend S and sent a letter before action purporting to challenge this decision. There was correspondence and it wasn't challenged.
I'm not sure this point is necessarily against you, because of course this is what Judge quashed.
Yes.
So if it's not a decision, then what has she quashed?
Well, that may be so, and she clearly hasn't quashed the decision of the 12th of November, which was the only decision challenged. She hasn't quashed the eligibility assessments, which weren't challenged, or the care plan, which also wasn't challenged.
Well, we'll come on to Mr. Justice Mostyn in a minute.
Yes, yes. So, well, the court below characterised this as a decision withdrawing funding for holiday. That's how the claimants regarded it, because they sent a letter before action, but they didn't issue a claim.
Okay. All right. So do we now go to the 12th of November? Is that where we're going to next?
Well, paragraph 10, I refer to the pre-action correspondence.
Yeah.
And then we go to the 12th of November decision.
And that's in the main bundle.
Court bundle 196.
196, 197. And
My lord,
this is a decision.
it is, my lord, yes. And it was characterised by the court as a decision to cease direct payments, which were being used for the claimant's outings or recreational activities, and that's how we would characterise it. That's paragraph 1 of the judge's judgment.
Can you help me with what it means by your advocate?
Yes. In addition to the mother's involvement, because of K and B's needs, they have support from a advocate, so not a lawyer advocate.
Is it an IMCA, Independent Mental Capacity Advocate?
I understand it's a care advocate.
Oh, yes.
May be corrected on that. My lord, before I go on, could I ask the associate to pass me some water, because I've managed to drink it all. My mouth is drying and I therefore may not articulate anything. That's brilliant. Thank you. I do apologise. Cheers, Dave.
It doesn't seem like the advocate was involved in the 3rd of March exchanges.
Wasn't. That wasn't to be okay.
Well, if you look at the beginning of the 3rd of March, it refers to correspondence from the advocate. So whilst that letter was not sent to the advocate, she was part of what led to that.
Shouldn't she have been notified of the decision if there was one?
I don't think there's an obligation to notify her directly, my lord, no.
Perhaps what I meant is, doesn't that indicate that it wasn't a decision?
Well, my lord, we say no, it doesn't, but...
Because you might think that you would tell the advocate of a decision.
Well, the November decision were obviously addressed to B and K. They weren't sent to the advocate. If that argument was correct, neither is a decision, and the challenge should never have been brought. Perhaps the concept of decision in judicial review is pretty broad. You very rarely get court saying you can't challenge this because it's not a decision. Courts may say it's not justiciable because it raises certain issues that aren't appropriate for the court to determine, but the court tends to adopt a very broad approach, and I don't think it ceases to be a decision because it wasn't sent to a particular person. If K and B were not aware of the decision, that might be relevant to an extension of time application if made, but time still runs from the date of decision, not date of knowledge. But I quite accept, if you're not aware of a decision, a court is very likely to grant an extension of time, provided you move swiftly once you know about the decision. But of course,
on one view, the decision was encapsulated in all three of these documents, not just in one of them.
well, they're different decisions. The eligibility needs assessment is a decision as to needs. The March decision is a decision that we're not going to fund holidays, and the November decision is that we're not funding activities. And of course, we also have the November care plan.
What is the precise decision in the November letter? On 196. You say it relates to activities. Seems to be rather broader than that.
Well, the decision there is direct payments will cease on the 29th of November. I think that was characterised in the N461, which is 168. Paragraph 169, section 3, details of the decision to be judicially reviewed. That is described as the decision by the defendant to reduce the claimant's care package to 0, date of the decision 12th of November 2020. So the claimants have articulated precisely what they are challenging and what they are not challenging. They're not challenging the eligibility assessment, and it's quite common for claims to challenge multiple decisions. That's not unusual. But in this case, the claimants have selected one particular decision and not challenged others.
My apologies, Mr. Chairman, but can I try and get this clear? Mm-hmm. This letter says the direct payments are ending.
Yes.
What it doesn't actually spell out is what those direct payments covered.
No, it doesn't.
It's only it doesn't spell out. It doesn't identify in any way what they covered.
I understand that, but it's directed to B&G, and they were aware that up till that point they were receiving, I think it was approximately £180 a week for recreational activities.
So you are saying that B&G are to interpret this letter, even though it doesn't say it, as to meaning that payments that they have received only for recreational activities are no longer to be made. Is that correct?
That's how we understand it, that's how the claimant understands it, and it's how Mrs. Justice Beverly Lang understood it. See, if we look at paragraph 1 of her judgment, that you'll find at A37 of the core bundle,
Well, that is claimants' outings and recreational activities. What's outings?
Well, that's going to, that may be going to the cafe, which perhaps isn't a recreational activity. Going to Mimsmere would be both an outing and a recreational activity.
And again, so I don't want to misunderstand any of this, prior to the sending of the 12th of November letter, is there any document emanating from the council which identifies accurately the basis for the hitherto made direct payments?
Manny, could you repeat?
Yeah. Prior to that letter, is there any document on which the local authority relies for identifying what was comprised in those direct payments, i.e., outings, recreational activities, anything else? Given you are sending it to B and K.
Well, I think you'll see from Mrs. Justice Lang's...
No, I'm asking for the council now, Mr. Sharland. A document emanating from the council.
Yes, and I was going to... Mrs. Justice Lang sets out in a lot of detail. So, for example, paragraph 24 of the judgment, the court doesn't have all the background documents because we didn't want to overburden you, but the court has set out the background, and you'll see, for example, paragraph 24 has got the support plan review, and over the page at A44, you'll see at the top of A44 what is being provided. Funding transport to get to places, and hobby purchases.
But that's in 2017.
Yes, my lady.
And it treats going to Florida as one of the going out.
Yes, my lord. And as the judgment goes through chronologically, you see it paragraph 33, the July 2018 care and support plan.
Why does the letter of the 12th, so the letter 196, why does that not incorporate the withdrawal of the holiday payments?
Well, we say that the claimants would have been told in March that the holiday.
They haven't. They were not told.
Well, the letter was addressed to their mother, but they wrote a letter before action challenging that withdrawal. So to say that they weren't aware of this, they weren't told.
I didn't say they weren't aware. And the question is, the authority would have to notify them, would they, formally, that you were withdrawing their holiday pay. And when you write in 12th of November 2020 saying that no further direct payments will be made, surely that is notifying them that all direct payments which were made to them to that point, including holiday payments, are no longer going to be made.
Well, we say that they were previously notified in March. I appreciate that the letter was not directed expressly to them. I was accused of splitting hairs previously, but
You're the one taking the technical point here.
Well, it's not a technical point, it's a jurisdictional point, that if a decision is not challenged, the court doesn't have jurisdiction. Pardon my lord?
They're usually the most technical of all. Anyway, well, certainly Mr. Justice Mostyn took the view that this November letter incorporated and built on the decision not to make holiday payments, and that's the basis upon which, as I understood it, he was giving permission.
Well, I am going to come to Mr. Justice Mostyn's
Okay.
in a minute.
Okay. Well, good. What do you want to say before you do?
I've just taken you to the 12th of November letter, which is paragraph 11 of my skeleton. Paragraph 12 deals with the care and support plans, which were finalised on the 27th of November 2020, and they're in the supplementary bundle. One further point, which is dealt with in my skeleton, but I haven't mentioned it orally. Respondent's litigation friend said that the eligibility needs assessments were not provided to the claimants in October 2019. They received them in November 2020. That's their case, and we're not in a position to take issue with it. What is clear is, at the date the claim was issued, the claimants did have them and chose not to challenge them. Paragraph 13 deals with the pre-action correspondence, and we're then on to the judicial review claim, which the claim form is at page 168 onwards, and I've already taken you to page 169, where the claimant articulates the decision being challenged. The claimant articulates it. And at the date of this claim being issued, they had the eligibility needs assessment, they had the March letter, they had the November care and support plan, but they elected only to challenge the 12th of November decision.
The remedy they seek on 170 is an order that you provide a revised care and support plan, including provision for them to have recreation and a holiday.
Yes. So although they haven't challenged the care plan, they're seeking relief in relation to it. What they're not doing is seeking any relief in relation to the eligibility assessments. So that's not challenged, no relief is sought in relation to them.
And if we look at the statement of facts and grounds, are you going to take us there?
You'll see at paragraph 1, claimants, 2 disabled brothers, seek judicial review of the decision.
It starts at 174, I think.
It does, my lord, yes. And paragraph 1, the claimant repeats what is said in the N461 form. The claimant's 2 disabled brothers seek judicial review, decision dated 12th of November 2020 by the defendant local authority to reduce care package to 0. So, if there's any doubt whether the eligibility needs assessments are being challenged, that we say it is clear that they were not.
And this is the document where we have the extra pages, but that's not immediately relevant. Well, when we get to the grounds for seeking judicial review on 191, paragraph 74, the claimants contend that the care plan is flawed and the defendant should be ordered to prepare a fresh care and support plan.
Yes, there is reference to the care plan being flawed. There's not reference to the assessments being flawed. But you have to articulate clearly. The claim form is an important document because everyone needs to know what is being challenged. And that sets out what is being challenged very clearly. And it's quite common for claim forms to articulate a number of decisions that are being challenged.
So what they're saying is, your decision to pay us nothing is challenged. The reason it's challenged is because your care and support plan wrongly excludes holidays and recreation. And you say that because the challenge isn't directly to the assessment which led to that decision, the claim must fail.
Yes, my lord. It's not a question of not being directly. The eligibility assessments were not challenged. Mr. Justice Mostyn didn't suggest they were challenged. Mrs. Justice Lang didn't suggest they were challenged. They weren't challenged.
I mean, this is... From a layman's point of view, i.e. litigants, the decision is you're not going to give us any money. And the reason you're not, the reason that's wrong is because your assessment was wrong. I mean, that's what they're saying, isn't it? And you're saying, oh well, you can't say that. You can't say because you didn't challenge the assessment.
Yes.
I mean, this is, you were complaining a few minutes ago about technicality. I mean, this is a pretty technical point.
No, my lord, it is trite law that decisions that are not challenged must be treated as lawful. There's Supreme Court, House of Lords authority on that point. This decision is not challenged on any interpretation of the claim form, statement of facts and grounds, Mr. Justice Mostyn's decision, Mrs. Justice Lang's decision. There was no challenge to the eligibility needs assessments. There would have been a need for an extension of time. There would have been.
So really, what you're saying is that even though the whole tenor of the, I'm saying this, if the tenor of the whole correspondence is this is still a subject for discussion and negotiation, they should nonetheless gone to court straight away in October 2019 as soon as they had that document.
Well, as I say, it appears that they didn't have the document in October 2019. They definitely had it in November 2020. It was something they were able to consider when they issued a claim.
I see. So you're not saying they should have. You're not making a point about time now. You're not saying they should have gone to court in October 2019. You're saying when they went to court, eventually they should have attacked the 2019 assessment.
Yes, and applied for an extension of time on the basis that they weren't aware of it at the time.
So what we're looking at to see if there is a material difference between the claim as formulated and the claim as you say it should have been formulated. And you say it should have been formulated specifically at challenging the 2019 assessment, October 2019 assessment, and the March 20 letter, as well as this ultimate decision in November.
Yes.
All that should have been wrapped up.
Yes.
And that would be materially different from what they said, which is we're challenging the November 2020 decision to cut it to zero because your care planning was flawed. I mean, that does, on one view, my immediate thought is that's a distinction without a difference.
Well, my lord, I had sort of got a feeling for the way the court was initially approaching this. I've got a few more points to make on this, but I'm quite aware that generally the court...
I mean, if you're going to tell us that the House of Lords Supreme Court says that that's wrong, then please, you must show us the authorities that say...
Well, I will be taking you to authorities on procedural rigor and authorities on the effect of a decision that hasn't been... the legality, what happens if you don't challenge a decision. So I will be coming to that. So we've looked...
Well, what the judge did in her order was that she made a declaration as a matter of law and then ordered your clients to prepare a fresh assessment. So it seems to me she's pretty clearly implicitly, if not directly, finding that the existing assessment did not proceed on the right legal basis. She doesn't actually say the assessment is quashed. Whether it's strictly necessary to do so, I don't know, but she said this is the law, you need to prepare a fresh assessment carried out having regard to the terms of the court's judgment. Now, It's all right to say she didn't technically say the assessments are quashed, but that is a real...
Well, with respect, my lord, she didn't have jurisdiction to quash the eligibility assessments because they weren't before the court, because they weren't challenged.
But it goes to the point my Lord Justice Phillips was making, that if her interpretation of the law is such that the assessments are made on a legally flawed basis, then that is a requirement for this public body to look at those assessments again.
Well,
We so ordered.
Yeah.
we say the court didn't have jurisdiction to examine the legality of the assessment because they weren't challenged. The court should have proceeded on the basis that they were lawful. I'm not sure I'm taking matters much, but I do want to take you to Mr. Justice Mostyn's decision and some case law on this.
When you get to Mr. Justice Mostyn's decision,
Yes, my lady.
what is set out in the statement of facts are the events that led up, because what they clearly show is that as between the council, perhaps Kate Chapman, perhaps Mum, there was ongoing correspondence, and it really again goes to another point raised by my Lord Justice Phillips, whether in fact the 3rd of March was a decision, or whether it was leaving open a ground for communication between the parties to see what could be resolved.
Well, if it wasn't a decision, the court erred in law in quashing it. There is no order quashing the 12th of November decision or the care plan, and there's no cross appeal against the order. So if that is wrong, nothing has been quashed, all decisions are lawful and extant. So it may be a point.
That's something that we can deal with, isn't it?
Yes. Well, I don't think you can. There is no appeal that says there should be a quashing of the 12th of November. There's no. We wouldn't be appealing that. It would be up to the respondents to appeal that, and they've elected not to do so. So that's not before the court. Similarly, there is no quashing of the eligibility needs assessment, and there is no appeal against a failure to do that. There's no application to amend the statement of facts and grounds in the N461 to challenge that decision. So what is before the court is relatively limited. It's our appeal on our grounds. The court can't just decide that a particular decision was challenged because there's no appeal against the absence of the court.
Maybe we should adjourn and see whether or not there's a respondent's notice and or cross appeal.
Well, there is a respondent's notice, but there's no cross appeal.
Cross appeal.
Yeah.
And the respondent's notice, in effect, looks at other statutes.
Other statutes. It doesn't cover this point.
Yeah, it does. And in the respondent's notice form, you have an opportunity to say we want to vary the order, and there's no suggestion that they want to vary the order, for example, to include quashing the eligibility assessment or quashing the 12th of November decision. So if the 3rd of March decision is not a decision, Mrs. Justice Lang erred in quashing it, and no decisions are quashed. They're all extant.
Well, at the moment, I don't understand why she didn't quash the 12th of November decision.
Nor do I.
Given her reasoning.
Well, yes. I find the order, given what was challenged, the sole decision challenged was the 12th of November decision, that is what relief should have been granted in relation to.
And judgment, when she gets to the decision on ground 1, does that help us? No.
It is somewhat unusual, I would say remarkable, that the order does not quash the only decision challenged, does quash other decisions that don't appear to have been challenged. But we are where we are. I can't sort of speak for the judge as to why she did what she did.
Well, you agree then that the logical outcome of her judgment is that the November decision should be quashed.
Well, yes, I can see that. Yes, but it's not open to this court to quash it because there is no cross appeal against the failure to do so.
Well, that's a technicality which can be remedied. If there's no substantive problem with it, I mean, it's not a matter which would require fresh evidence, or which it seems to me. I mean, if obviously there's the underlying substantive arguments, but if you accept that given her reasoning, the judge should have quashed the 12th of November decision, then I don't think that should present a problem, and I'd be surprised if the local authority would really wish to present that as a problem.
Well, my lord, I hear.
I'm surprised that the local authority didn't seek to clarify the order in that regard, given they must have wanted to know which of their decisions were or were not. Presumably, they were involved. Were they involved in drafting?
Yeah, well, I think counsel for both parties produced a draft order which reflected their understanding of what the court had decided. That was sent to the court, and the court approved it. So that is the court's order. That there was input.
Well, the judge's conclusion, the very last paragraph, is the claim for judicial review is allowed on grounds 1, 2, and 5, and that claim was to quash the 12th of November decision. So it seems to me that the order doesn't reflect the judge's judgment. It seems to me it's almost a matter of the slip rule, isn't it? She plainly allowed a claim to quash 12th of November decision, and that hasn't been reflected in the order.
I mean, the usual practice would be that the parties are normally invited to draft the order, are they not?
I just explained that that's what happened. Yes.
Yes. You know that's what happened.
Yes.
Yes, thank you.
Yes,
Right.
that's what happened. A draft order was sent to the judge, and she approved it.
If we yes, 142 to 143 of her judgment at A88. The reason why she says ground 1 succeeds, she takes it back to the assessment. By tailoring the assessment at 142 in this way, the only need identified was care and support for SQ. As SQ remained willing and able to provide care, claimants, the council had no duty to meet the claimant's needs. Consequently, Miss Eden wrote to the claimants on the 12th of November. In my judgment, the erroneous interpretation of its powers tainted the eligibility assessments by leading to a misguided exclusion of aspects of the claimant's needs. The council then failed to consider whether financial support should be offered to meet those needs. Therefore, the council cannot rely on the eligibility assessments to avoid liability under ground 1. Now, on one view, one might say that that's leading to a quashing of the October assessments and the November decision, but instead, what's formally quashed on the order the council drafted was the March letter.
Yes, my lord, and we make the point in our grounds of appeal and the skeleton that the judge adopted a wrong approach on ground 1. She needs to start off with what is not challenged, i.e. the eligibility assessments, and then consider whether in light of those unchallenged and therefore lawful eligibility assessments, but perhaps I'm repeating myself and not assisting the court. I'm slightly concerned about the time, and obviously I've still got a bit to cover. You want to hear from my learned friends, and
let me just tell you. All right. What's your next point?
Well,
we haven't got to Mr. Justice Mostyn yet.
No, let's turn
always a
to Mr. Justice Mostyn.
Lodestar in my considerations.
That's page A151 of the core bundle. Now, we have the order of Mr. Justice Mostyn set out at 151. Application for permission to apply for judicial review is granted on various grounds. Permission is refused on ground 6. Application to be listed. There is no order extending time to challenge the 3rd of March decision there. We do have observations, but they are not the order of the court. And of course, the claimant had not applied for an extension of time to challenge the 3rd of November decision. The N461 form has a section, are you applying for an extension of time? That wasn't ticked. So we have no application to extend time. We have no order extending time, but we have observations. Now, I'll take it briefly. We say those observations are not an order. They don't extend time for a decision that wasn't challenged and where there was no extension sought.
So what? You are taking a technical point where he says in paragraph 1 of the observations, if I'm wrong about that, namely the claim is not out of time, time should be extended, and this relates to the March 20 decision, given the ongoing nature of the discussions and the clearly arguable points of law, which these, and that's it. But he refers there to the ongoing nature of discussions. That is reflected in the statement of facts, which accompanied the original form.
Yes,
so it's a technical point. So because he has not put in his order, if I'm wrong, you should extend time, the fact it's in the observations, what, has no weight?
Well, I'm not sure he could make an order extending time where there's been no application to extend time. That may be why he didn't make the order. I don't know. This case is, to put it gently, a little messy. There was no articulation that the 3rd of March decision was challenged. There was no application to extend time to challenge the decision. The claimant has expressly said on every occasion possible, we're challenging the November decision. So that may explain why there's no order. But I get the point that the court is saying about the technicality. It's a technical point. What we do see from Mr. Justice Mostyn's decision is he is not purporting to extend time to challenge the eligibility needs assessments. It's only the 3rd of March letter.
Well, there's substantive points of law here, which have been decided very clearly and which are before us. It's a matter for the council if it wants to take technical points. Of course it is. But we might take the view that for a local authority that has been found by a judge to have taken the wrong view on the point of law, that they would want to challenge that point of law, but if they're wrong, would want to action that in the way that they deal with claimants such as these individuals, rather than take the view that if they're wrong as a matter of law, they would wish to continue to act on the basis of an incorrect position of law because the formalities were not, the I's were not dotted and T's were not crossed. For my part, I find that a surprising point of view for a local authority to take, a public body to take, given their wider duties in such matters.
Well, my lord, permission was granted to advance this argument.
Well, something of a side wind. You've read Lady Justice Simler's reasoning, and her primary concern was the substantive issue was a matter of importance, possibly, or certainly arguable. She said you could also take this point as well.
Well, yes, she granted permission on all points. I think, given the court's initial view on this, I do want to take you to a bit of authority, but I don't want to spend too much time on it because I think the court wants to move on to the what it regards as the key issue.
No,
I'm trying to address every question.
We are concerned about both grounds.
Yeah.
So we want you as to have an opportunity to cover anything you want to say on both grounds. So where do we go on? Is it on ground 1 you want to take us to some authorities, did you say? Have we finished with Mr. Justice Mostyn?
I have, and the critical point is on no reading of that is an extension to challenge the eligibility assessments. The court's obviously looked at both the judgment and the order, and at paragraph 24 of my skeleton, I make various points about actually what the order says, and of course the court's got those points. Paragraphs 26 to 33, I set out the legal background. I think it would be useful to look at that now because it's going to be relevant to the second point, ground of appeal, second and third ground of appeal.
So we're on page, I've got it internally, 8 of your skeleton argument. Is that right?
Paragraph 26.
Bottom of page 8 on my...
Yes, I'm working from a speaking note, so the pagination's changed, but the paragraph numbers haven't.
26, under the heading legal background.
Yes, yes.
Yep. And then you set out section 9.
Yes. So, under the Care Act, there is a chronological process. The first part in that process is the assessment of needs, which is dealt with in section 9, and what is being assessed are needs for care and support. So it's not K's general needs, it's their needs for care and support.
And such needs may be eligible or non-eligible.
That's correct, my lord, yes.
And in respect of eligible, you have a duty.
Yeah.
And on non-eligible, a power.
That's correct, my lord, yes.
I mean, that's crudely.
Yeah,
That's
yes.
the
Yes.
structure.
So first need to assess needs for care and support, and that, so the meaning of that phrase is critical to the second ground, and I'll come to make submissions on that. But the broad point is it's not all needs. Individuals who are disabled have needs for food, for clothing, to have a social life, recreational activities, holidays and so forth. But section 9 is not to meet all needs, it's just needs for care and support.
Yes.
That qualifies it, and the critical issue is what are needs for care and support.
Yes.
And such an assessment is carer and resource blind. The fact that a carer is currently meeting those needs does not negate the need for an assessment. The provision of care from a carer is relevant to the decision whether to meet the needs in section 18. Next relevant provision is section 13, which sets out the eligibility criteria. Prior to the Care Act, you had postcode lotteries. You had different approaches in different areas. And one of the new innovations in the Care Act was to have a national approach of eligibility criteria. Section 13, where a local authority is satisfied on the basis of a needs assessment that an adult has needs for care and support, it must determine whether any of the needs met the eligibility criteria. And that takes us to tab 6 of the authorities bundle.
We were earlier, actually.
Yes, which we have already looked at.
I think, yes.
Yeah.
An adult's needs, i.e. an adult's needs for care and support, meet the eligibility criteria if the adult's needs arise from or related to a physical or mental impairment or illness. So we say that a universal need, obviously that individual has a need for food, but that need for food does not arise from or related to physical or mental impairment or illness. Second is result the adult's needs. The adult is unable to achieve 2 or more of the outcomes specified in paragraph 2. And thirdly, consequence likely to have a significant impact on the individual's well-being. And we have already looked at the specified outcomes. And we say that how they are worded is important. So specified outcomes relate to managing and maintaining nutrition. So as I said earlier, that relates to care and support to enable someone to eat. It doesn't relate to the provision of food, because that is not what that is not.
That's not an eligible need.
Well, we say it's not a need for care and support.
Why do you say that?
Because we say a need for care and support is a need to be looked after.
And I know we're going back. Where do we find? Why do you say that?
Well, because there's first instance case law that has suggested that that's what that means, relying on House of Lords case law.
The need for care and support is a broader category than eligible needs.
Yes, my lord. But it's not all needs. It's just needs for care and support.
These provisions cover eligible needs. They don't define needs for care and support.
That's correct, my lord. Yes. Yes, the eligible needs are a subset of needs for care and support. And we say the need for food is not a need for care and support. We also say it's therefore not an eligible need, but if you're against me and you conclude it is a need for care and support, we say it's also it's not an eligible need. So in that situation, if you're with me that food is not a need for care and support, there would be no duty to provide it under Section 18 and no power to provide it under Section 19. If you're against me and you conclude the need for food is a need for care and support, but it's not an eligible need, there would be no duty under Section 18, but there would be a power under Section 19. We say it's neither, because needs for care and support are looked after needs.
Does this structure, how to express this, does this structure in Regulation 2 mean that so 2(1)(b), all adults who are unable to achieve two or more of the outcomes in paragraph 2,
Yeah.
all their needs are eligible? Or only those needs relation to those specific outcomes which they are unable to meet?
My understanding is the latter. I don't think anything turns on it in this case. Of course, an individual may have a need for food, clothing, housing, but that need may not arise from physical or mental impairment. They may be destitute, for example. So someone may have a need for such matters, but this would not be the relevant provision to provide food, clothing, accommodation, because there are other regimes that provide for that. And as we know, both claimants are receiving between them approximately £500 a week. So in relation to holidays and recreational activities, the eligibility assessment that we looked at earlier today concluded that there were no need, that they were not needs for care and support, and therefore it obviously follows that they weren't eligible needs. The court, if the court looks at ground 2 on a hypothetical basis, the court will want to consider whether they are needs for care and support, and if they are, whether they are eligible needs, because that will give guidance on whether it's Section 18 or Section 19.
Well, it's not really a hypothetical basis, is it? Because we have, as was set out in detail in the judgment, previous care plans and your concession to a question from me this morning, that their needs haven't changed. When I say needs, let me phrase it another way, that their mental and physical state has not changed.
That hasn't changed, but their assessed needs have changed.
Yeah, but that's based on a legal interpretation, which was previously said to be wrong.
Well, it's based, we're sort of perhaps going around and saying, it's based on a decision that is not challenged in this litigation. But I don't think I can assist you any further on that point at this stage. So to be an eligible need, it must arise from or are related to physical or mental impairment or illness. So we say a need for food doesn't arise from or is related to physical or mental impairment or illness, because that arises regardless of whether someone has a physical or mental impairment or illness. Similarly, clothing. We say similarly activities and holidays. So that is just sort of flagging up our argument why we say they are not eligible needs, even if we're wrong, and they are needs for care and support. Next relevant provision, which is set out paragraph 30 of my skeleton argument, section 18 of the Act. This is the provision and you'll find this in tab 4 of the bundle if you want to look at the underlying document rather than my skeleton argument. Critical subparagraphs are 1 and 7. 18.1 says the local authority, having made a determination under section 13, i.e. what are the eligible needs, must meet the adult needs for care and support which meet the eligibility criteria if ordinary resident, CAP, etc., etc. And A, B and C are not relevant to this case. You'll see over the page, subsection 7 says the duties under subsections 1 and 5 do not apply to such of the adult's needs that are being met by a carer. And you'll recall from the assessment that all the eligible needs, all the needs were being met by a carer, and therefore there was no duty under section 18 to meet those needs. Section 19 is the power. And as my Lord said, in relation to needs for care and support that aren't eligible needs, there is a power but not a duty to meet those needs. Don't think we need to look at these in any detail, but for the court's reference, paragraph 32, 33, I set out sort of the care planning, what has to be done after the needs assessment, the contents of the care and support plan, and then personal budgets and so forth. Which takes me to paragraph 34, or ground one of the appeal, and we've obviously spent quite a bit of time on ground one, so I hope to take that relatively quickly. Paragraph 34, I set out the sequential approach that the council is required to follow. That sequential approach was followed, and you've looked at the underlying documents. Paragraph 35 refers to the October 2019 assessment. It concluded that the respondents had various eligible needs for care and support. However, it did not conclude that respondents had a need for holiday or recreational activities. And then 36, in relation to various eligible needs, they were being met by the respondent's mother, and therefore there was no duty on the council to meet them. Now, paragraph 37, flag up the point which you've obviously already got. Parents' eligibility needs have not been challenged in this litigation or elsewhere. We say it's well established the decision is lawful and has full effect unless until court of competent jurisdiction decides otherwise, and the court has emphasised the importance of procedural rigour, of the claimant clearly identifying what is being challenged and the grounds of challenge. And if I could take you briefly to two authorities on procedural rigour, my lords and my lady. Firstly, the case of the PEDA, which is at tab 24.
Second model.
So this was an immigration matter, immigration judicial review. The underlying facts do not matter in relation to this. Lord Justice Singh gives a concurring judgment from paragraph 55 onwards. He agrees with Lady Justice Hallett that the appeal should be dismissed, but wishes to add observations on a couple of matters. Firstly, the concept of fairness in public law, and secondly, the need for procedural rigour in public law litigation. That's paragraph 55. And he addresses the procedural rigour point at paragraph 67 to 69. And rather than I reading them to the court, it might be easier if the court reads paragraph 67 to 69 to themselves. There's one other authority on procedural rigour, which is at tab 29, also the second volume, case of Dolan, recent Court of Appeal, relatively recent Court of Appeal judgment. This is one of the coronavirus regulations cases. And you have the judgment here of the court, which was Lord Burnett, Chief Justice, and Lord Justices Singh and King.
Lady Justice King.
Lady, I do apologise. The relevant passage is at paragraph 116 through to 118. If I could ask the court to read that.
It's a slightly different point being made in 118, but it's a development of the point you're making.
Yeah, yes, it is. I appreciate that the paragraphs I've just taken you to deal with other points sort of beyond what is in issue here, but this is very clear and important jurisprudence on the importance of procedural rigour. You need to identify what decision is being challenged and on what basis. That is what the claim form and the grounds are there to do. The claim form asks you to articulate precisely in section 3 what decision is being challenged in this case. And that's absolutely critical because the parties need to understand what is being challenged.
And in this case, the claim form said what's challenged is the decision on the 12th of October. 12th of November,
yeah,
2020,
yes,
because of the defective way in which the assessments were carried out.
Well, I don't think that's what the claim form does say.
Well, not in so many words, but that's an effect.
Well, no,
you're paying us. You decided to pay us no money because you've approached the assessment of what you're obliged to pay erroneously. That's what it's saying, isn't it?
No, I don't think it is an implicit challenge to the eligibility assessments. And you can't implicitly challenge decisions in judicial review. You're supposed to articulate in the pleadings. That's the purpose of the pleadings, and the Court of Appeal in these two judgments have emphasised the importance and the need for the court to take this seriously. And you'll see the reference to the court needs to robustly enforce this, not ignore essentially the claim form, not ignore the repeated articulation that the only decision challenges the November decision. Mr. Justice Mostyn's judgment, the decision, on one reading gave permission to challenge the March decision and the November decision, but on no reading did it give the claimants permission to challenge the eligibility assessments, we say, and therefore that issue was simply not before Mrs. Justice Lang. And as I say, the court have emphasised why this is important. Of course, there is a public interest. This isn't private litigation, but it is important that everyone knows where they stand, what decisions are being challenged. My lords, can I now take you to the authorities on the effect of the legality of decisions that are not challenged? I cite two authorities on this point. The first is Smith and Rowe, which is tab 9.
Can I just clarify though, none of these points that you're now making were taken before Mrs. Justice Lang, were they? They're not in the skeleton, and she doesn't deal with them.
Well, the skeleton responds to the claimant skeleton, which says in terms, the only decision I'm challenging is the 12th of November decision. So the skeleton in response is not going to say, well, you can't challenge the eligibility assessments, because the claimant skeleton, which you'll see at Core Bundle 118, says this is the final hearing of the claim for judicial review of the decision dated 12th of November 2021. So when the defendant counsel drafted the skeleton in response, the eligibility assessments were not challenged.
But why are you making the point for us now?
Because the judge below, notwithstanding they weren't challenged, considered their legality.
But she didn't make an order.
Well, she didn't quash them, but she made an order that she implicitly suggested that they were unlawful when they weren't challenged.
Surely it would have been just as important a submission to make before her. This is all very well and good, challenging the November decision, but you haven't challenged the eligibility assessments, and so this is all written water, and the court doesn't make academic decisions in judicial review findings. But nowhere, as I understand it, was it said to the judge below that this is all no use because there's no challenge to the eligibility criteria, which are deemed to be lawful.
Well, if you look at page A144, paragraph 21 of the defendant skeleton below.
Can you give me the reference again? Sorry, it's
A144.
Thank you.
There is no direct challenge to the assessments, and they are plainly lawful. Claimant challenging a social care assessment has a heavy burden. See the Court of Appeal's decision in Irena's Child. And there's also a judgment of Mr. Justice Chamberlain. So what is being said below is what I'm saying now. They're not challenged, and they're clearly lawful. So the argument was articulated. I appreciate it's been developed slightly more today, albeit I have permission to develop it. It's not something that the court said I couldn't develop. But I don't accept that this point was not made below. It was said in our skeleton argument, notwithstanding the claim only challenges in the November decision, the assessments aren't challenged, they're plainly lawful. and then there's case law on the fact that courts should be deferential to such assessment.
I do see that it's in the skeleton. It's paying not a point which was certainly which Mrs. Justice Lang ultimately decided she had to deal with.
Well, that may be so, but
So I don't know whether it was dealt with orally.
but I think that led to the error. It's made clear in the defendant's skeleton, these aren't challenged, they're lawful, and therefore you need to work on that basis looking forward. That's not what she did. She considered in the abstract whether the needs for holiday and recreational activity could be needs for care and support, or needs for care and support. I don't think she actually considered whether they're eligible needs, and then said, can the defendant rely as a defence on the assessment? But that's not how it works. You start with the unchallenged and lawful assessments, and you then move forward, bearing in mind they are unchallenged and they have concluded that there is no need for a holiday, no need for recreational activities. Was the November decision to no longer make direct payments lawful? And the answer to that is clearly yes, because there is a lawful decision that there are no eligible needs that are unmet.
In addition to the duty to meet eligible needs, you had the power to make payments for ineligible.
Yes, ineligible.
Forgive me. Ineligible
Yes.
needs. Where do you indicate to the claimants that you were not going to exercise that power?
Well, the needs assessment sets out the needs and what are the eligible needs.
Does it?
We say it does, yes.
Can you just show me where it does? And furthermore, whether the question of the discretionary power is referred to in the letter of the 3rd of March. It may be that it is. And
I don't believe it is, Michael.
Okay,
No.
so can we look at go back to the assessment? So this is...
So supplementary bundle A29.
Right.
So
Just bear with me a second. Just going back.
Of course, my lord.
So this is an eligibility assessment.
Well, it's a care eligibility assessment. It assesses needs for care and support and whether they're eligible needs.
Okay.
So
Just show me where it does that.
yes, A35. In the second column, you have the needs for care and support articulated, set out.
What are the worries and concerns?
Yes, I quite accept that the heading could do with some improvement. But there you have the needs for care and support. And the next column is, are they eligible needs, are they ineligible needs? And in relation to all the needs identified, they were all held to be eligible needs.
Hang on. Why do you say the last column is ineligible?
I didn't, my lord. No, sorry.
Sorry?
The second column are the needs for care and support as assessed.
Yes.
The third column tells you the council's conclusion as to whether those needs are eligible or non-eligible. If they were said,
my mistake.
If they were said to be non-eligible, and that's sort of an option on the drop-down, there would be no duty under Section 18, but there would be a power under Section 19. The final column relates to Kay's wishes, but they are not eligible or uneligible needs, illegible needs.
I mean, these the headings within the document are referable to the eligibility headings, aren't they?
Yes, yes, my lord.
There's no. But you say nonetheless that this is a global assessment of needs, not just eligible needs.
Yes, yes, my lord, because if it was just eligible needs, the third column wouldn't be needed. The third column tells you whether it's an eligible or uneligible need. The second column tells you what the care and support needs are.
Well, just on page A35, the left-hand column are the outcomes domain.
Yes.
All right? Not everything in the outcomes domain is eligible because in addition to being within the outcomes domain, it has to meet other factors in regulation 2.
Mm-hmm. Yep.
So isn't it arguable that the eligibility column relates to that? And that the whole of this document is focused only on eligible needs and doesn't deal with ineligible needs at all.
Well, it doesn't deal with ineligible needs because all the needs identified were assessed to be eligible.
But that, hang on a minute, simply because all the needs of the document here were assessed as being eligible, it doesn't mean that B and K had other needs which weren't eligible.
Well, the document says there are no other needs for care and support that are not eligible because there's no...
Just show me where it says that. Really.
Well, basically, from A35, there's no needs described as ineligible.
But the structure of the document is only focused to eligible needs.
No, my lord.
This is an eligibility assessment.
No, the document looks at the various outcomes, which are broad. But the fact that my lord, the council's understanding of the document and my submission on the document is this document considers...
Let me put a proposition to you. Maybe you want to
Yeah.
do it at 2 o'clock. My proposition is this. The focus of this assessment is on eligibility. It's not on total needs. It's on eligibility. As you accepted that was all that the letter of the 3rd of March was focused on. So it was only when they got the letter on the 12th of November that they knew that not only would you not be paying for eligible needs, you also wouldn't be exercising your power in respect of ineligible.
Well, my lord, we say the 3rd of March letter deals with the one-off payments for holidays and makes clear that they won't be made going forward. We say the November decision deals with the other matters, the weekly direct payments for activities.
I see.
Well, where in the assessment do we find an assessment as to the holiday position?
Well, you find it in its absence because it's not articulated to be a need for care and support or an eligible need. So
there's no box for it, is there? Where would it come if it had been looked at?
Well, I think it was put to me by the court that could have been included on developing or maintaining family or other personal relationships. And there could be eligible needs within that outcome domain, but in uneligible needs.
I think what you're saying, what you're putting to us is that because this document and it's the decision it represents isn't challenged, therefore the effective decision in relation to holiday needs is lawful. But I can't see in the document, as my lord has been examining with you, where there is any decision about holiday needs in the document.
Well, there is no reference to holidays in the document, and the absence of inclusion of that in the needs column means the council has assessed that is not a need for care and support. Because that's what the second column is setting out, the needs for care and support. So if it's not in there, it's not a need for care and support.
If you go to page 433, and specifically where, leaving aside the relationships issue, that's where one arguably might expect to see holidays under the making use of necessary facilities, etc. The way it's constructed, the whole box section of the form is constructed, is about local community. It's not about holidays at all. So I think my lord's right, isn't he, that this document doesn't look at holidays at all.
Well, the court suggested to me that holidays would fall within the developing or maintaining family or other personal relations.
Well. Okay.
And we had a little debate about whether holidays.
You didn't accept that.
So it could have been included there, but the fact it wasn't included as a need for care and support. And of course, this document is not setting out all of Kay's needs, because Kay has a need for food, for clothing, etc., etc.
It has ineligible needs that aren't covered for in this document.
Yeah, well, in this document, the
So
conclusion.
where are they covered?
No, they
Where
are.
are they assessed?
Well, we say they are covered, but the council concluded that there weren't any ineligible needs.
When did you decide that that they didn't have any ineligible needs, but needs which or any ineligible needs? Where did you decide that?
Well, that is what this document decides. A35, second column sets out needs for care and support. Third column says, are they eligible or not eligible? My lord, I can't take it any further. That's the argument. You may not be convinced by it, but I don't think repeating it's going to...
Well, thank you very much. I'm conscious we've interrupted a lot. Now, you've got to deal... Have you finished with all you want to say on ground one?
I haven't managed to take you to Boddington or Smith, which I can do very quick.
Okay, do that at 2 o'clock. And then, how long do you think you're going to be on ground 2 and 3?
2 and 3. I would hope I'd be done within 45 minutes, but it obviously depends on how many questions I'm asked and how long it takes me to deal with those questions. And so I don't want to confidently predict I'll be done in 45 minutes, because this morning has taken a lot longer than I expected.
Well,
and I apologise for that.
No, don't apologise, Mr. Charland. You've had to deal with a lot of interventions in the court.
Yes, mainly from me, Mr. Charles. My lady will be looking at me when we go out for course. I wonder whether we...
Yeah, that's fine.
Do you think we could start at 10 to 2?
Of course, my lord,
Would that be convenient for everybody? I'm sorry to the court staff. It's a slightly shorter lunch break. Let's meet back. Let's resume at 1:45. Look forward to seeing you all back.
Oh, did you say 10 to or quarter to?
Sorry? 10 to.
10 to.
10 to.
Leaving the chair in her way.